This is an application in the matter of RTM and Bonne, Terre Limited and another.
Good morning. Together with my junior Robin Hopkins, I appear on behalf of the appellants in this matter. My own friends Christopher Knight and Arushi Sahor appear on behalf of the respondent, RTM, and Heather Emerson and her junior Jack Steele appear on behalf of the ICO. Oh, I'm so sorry. I've mistaken the identity of Mr. Knight's junior. It's Jennifer McLeod. Apologies. In terms of the materials before the court, we're hoping that you have a core bundle, a supplemental bundle, and an authorities bundle. There have been some additional materials that were emailed to the court, and we have hard copies that I understand are in front of you now. They comprise, first of all, a somewhat wider extract from the GDPR so that you have a better sense of the architecture of the legislation. And then we've also handed up a screenshot concerning our GDPR consent mechanism. The extract from the GDPR we invite you to insert at the end of the authorities bundle. And the screenshot we'd invite you to insert in the supplemental bundle after page 163.
Thank you.
In terms of the structure of my submissions, I propose to proceed as follows. First, I plan to address the court on the broad background of the appeal. Second, I'll then look to set out our case on appeal in outline. Third, I'll then seek to take the court through the relevant legal framework. So in this section of my submissions, we seek to assist the court both by giving you a sense of the broad nature of the framework and also by explaining as we go along how we say the test of consent falls to be construed and applied. Fourth, I'll address the court specifically on the jurisprudence and the guidance on the issue of consent. Then fifth, I plan to take you through the judgment in some detail. That exercise does need to be detailed in this case because, of course, there is a fairly fundamental dispute as to how the judgment falls to be construed. Then sixth and finally, having taken you through the judgment, I'll turn to address the court on our grounds of appeal. And just to give the court the heads up, I plan to deal with the grounds in the order in which they appear in our skeleton, save that I'm going to deal with ground 3 at the end of our submissions for reasons that I'll explain in due course. Now, I note for completeness that we've set out our case on disposal of the appeal in the event that we succeed. Our position is set out in the written arguments that were sent to the court last month, which you'll find at tab 20 of the core bundle. I don't propose to say anything on the issue of disposal in our opening submissions today, not least because we don't yet know what position RTM takes on our submissions. So moving on then to our first topic, which is the background to this appeal, we say the background can be summarised as follows. My clients are providers of online gambling services to members of the public. For convenience and in common with the judge, I'll refer to my clients collectively as SBG. The respondent, RTM, is an individual who formerly used SBG's services. We accept in light of the judgment that RTM was all material time suffering from a gambling disorder. The court labels this disorder as a gambling addiction, but it is important to note that as we see from paragraph 156 of the judgment, the court rightly concluded that it couldn't proceed on the basis that RTM had a medically diagnosed disability, there being no medical evidence of any kind before the court. Equally, and as is also clear from the judgment, the court accepted that whatever the impact his disorder had on his mental state, it did not mean he lacked general capacity, as the court put it, such that he could not, for example, enter into effective contractual relations with SBG for the provision of gambling services. We see the court accepting that RTM was capacitous in that sense in the judgment at paragraph 157. I'm going to come back to that point in due course. In 2003, RTM brought a claim for damages against SBG in connection with certain data processing and technical activities concerning him, which SBG had undertaken, specifically over the period early 2017 to late 2018, early 2019. This period is referred to in the judgment as the relevant period. See paragraph 15. Now, in broad terms, 3 activities were put in issue by the claim. First, my client's placing of cookies on RTM's devices. Second, my client's internal marketing-related data processing activities concerning RTM, including its marketing-related profiling activities. And then third, my client's sending to RTM of various gambling-related direct marketing emails. With respect to the cookie placement activities and the sending of direct marketing communications, RTM claimed that these activities were unlawful as being in breach of, respectively, Articles 6 and 22 of PECA, which is to say the Privacy and Electronic Communications Regulations 2003. With respect to the internal marketing-related processing activities, RTM claimed that these activities were unlawful on an application of the data protection legislation. And as I'm sure the court will have appreciated, over the period of the claim, the applicable data protection legislation changed up to and including the 24th of May 2018, the Data Protection Act 98 applied. From the 25th of May 2018 until the end of the period, it was the GDPR. PECA, by way of contrast, applied throughout the period. For completeness, I should add that RTM also argued that our activities amounted to a common law misuse of private information. I do not propose to say anything more about the misuse claim in my submissions because, as the court can see from paragraph 208 of the judgment, the court below held that that claim added nothing to the data protection claims, had not been substantively pursued in oral submissions, and was inherently unlikely to succeed, and the court's conclusion on that claim is not an issue on this appeal. Coming back to how the claim was framed, RTM claimed not only that these various activities were unlawful, but that they caused him to suffer damage comprising both pecuniary losses and distress. The pecuniary loss claim was based on an allegation that the direct marketing emails that RTM had received had exacerbated his gambling disorder, causing him to gamble more and lose more than would otherwise have been the case. RTM claimed compensation from my client in respect of this alleged damage. Now, RTM's claim that the relevant activities were unlawful under the data protection legislation was put on a number of different bases in his pleadings and indeed in his written arguments before the court. But as the court rightly reflected at paragraph 77 of its judgment, before the court, the focus of the arguments was essentially on the question of what, if anything, RTM had consented to. It being common ground between the parties that the placement of cookies and the sending of direct marketing communications could only lawfully have been undertaken by my client in circumstances where RTM had validly consented to the same. In short, RTM claimed he hadn't validly consented to those activities, and we took the opposite position. Now, we'll come on in due course to examine precisely how RTM put his case on consent, because that is an important issue in the context of ground 1 of our appeal. But in any event, as we see from the summary conclusions set out in the court's judgment, paragraphs 201 to 208 of the judgment, the court resolved the consent issue in RTM's favour. In summary, the court concluded that RTM had not validly consented either to the cookie placement or to SBG sending him the relevant direct marketing emails, and that it followed that those activities were unlawful under PECA. The court further held that it necessarily followed that our internal data processing to enable our direct marketing and our direct marketing personalised emails to RTM, that activity was also unlawful for the purposes of the data protection legislation. The court's reasoning on that issue is set out at paragraph 205 of the judgment. It can be summarised as follows. SBG had relied on legitimate interests rather than consent as being the lawful basis for its internal marketing-related processing activities. However, given that RTM had, in the court's view, not validly consented to receiving any direct marketing from SBG, there was simply no legitimate interest that was served by this internal processing in the court's view. And indeed, in the court's view, my client had in any event conceded that it had no legitimate interest in conducting such processing because it had conceded that it had no such interest in conducting such processing in respect of individuals who were in fact problem gamblers without their consent. So the court concluded, therefore, that our internal data processing had no lawful basis, and so was also unlawful under the data protection legislation. As the court confirms in paragraph 206 of the judgment, it did not decide any of the wider issues raised by the claim on the basis that it felt it didn't need to do so, given its conclusions on the consent issue. And what that meant was that, for example, the court did not decide RTM's claim that our processing had breached the requirements of Article 9 of the GDPR. That claim would have required the court to determine the contested issue of whether the data that we were processing in our hands amounted to special category data for the purposes of Article 9.1. The court also therefore did not resolve other disputed issues, including whether our processing was fair, whether it was transparent for data protection purposes, nor his wider claims concerning purpose limitation, data minimization, and data retention. And just for your notes, you get a good sense of the wider case which RTM was advancing through his claim by looking at section 2 of his opening skeleton below, which you'll find in the supplemental bundle, pages 281 to 292. By our appeal, we seek to challenge the court's judgment, say that, as you'll hopefully have seen from our skeleton, we do not challenge its ultimate conclusion that our placement of cookies on RTM's devices was unlawful. As we confirmed in our skeleton, we have, for pragmatic reasons, decided not to challenge that aspect of the judgment, particularly taking into account the objective quality of our cookie mechanism, our cookie consent mechanism at the time, and that our cookie consent practices have subsequently moved on. For the avoidance of doubt, however, we do challenge the court's separate finding that our cookie placement activities serve to enable our internal marketing-related processing insofar as it pertains to the claim. That is our ground 4, which I shall come to in due course. Having set out the background, I want now to turn to our second topic, which is our case in outline in this appeal. Now, the first point I want to make is, whilst this is undoubtedly an important appeal, indeed we understand it's the first occasion on which this court has been asked to consider the issue of consent under the data protection legislation, so it is certainly an important appeal. Nonetheless, we say that the issues that it raises are not difficult to resolve. What we say, in short, is this. First, the court decided the consent issue that was before it by applying an essentially subjective test, one that focused on the fact of RTM's gambling disorder and the impact that it had on his subjective state of mind. We say that is the only way in which this judgment can sensibly be read, and we say that RTM's contrary arguments, whilst very skillfully advanced, no one can question that, those arguments are, we say, simply not tenable. Second, we say that that straightforwardly warrants the judgment being overturned because the test for consent under the applicable legislation is not subjective. And indeed, we say it does not admit any subjective element. We say the test for consent does not concern itself with the inner workings of a data subject's mind, something that is essentially unknowable, judged from the perspective of the controller. Instead, it concerns itself with what, judged objectively, the controller ought reasonably to have surmised as to the data subject's state of mind at the point that they assented to the relevant processing activity, judged in the context of their relationship with the data subject.
So you accept, do you, that in some circumstances the data controller does know about the data subject's state of mind?
So we accept that there may be circumstances where in the context of the relationship, the controller either already has information before it, or alternatively ought reasonably to have had information before it that indicates, for example, that the person lacks capacity. In those circumstances, we would
lacks capacity and by what test?
Well, that's a very good question. I mean, the example that I was giving, let's just take the standard test of incapacity that's set out in the Mental Health Act.
Well, that's decision specific.
Yes.
You have capacity to do one thing, but not another.
So let's just assume for the sake of argument that the controller has information before it, or ought reasonably to have information before it, indicating that the individual is mentally impaired such that they can't make free choices around marketing consents, for example. We would accept in those circumstances, the controller would not be able to discharge its obligation of demonstrating consent, which is the obligation provided for under the legislation, because we would not be able to establish effectively that the consent was freely given.
I know that this is your case, but when you use the phrase ought reasonably to have, what do you mean by that?
So there may be circumstances in which the nature of the industry is such that you would expect the controller potentially to go through certain steps to ascertain whether, for example, in this context, they are dealing with a problem gambler. And so in circumstances where, for example, there has been a fundamental deficiency in the controller's process, that means that if they had complied, for example, let's say with their safer gambling obligations in the context of the gambling industry, they would have had information before them confirming that the individual was a problem gambler. We say in those circumstances, even though the individual had opted in to receiving direct marketing, that the controller could not properly proceed on the basis that consent was valid.
But the capacity would presumably differ according to whatever it was that the data subject was doing online, and whether it's ordering something from Amazon or booking a holiday or whatever.
Yes, so these issues are always context dependent. You have to look at the nature of the industry you're concerned with, the nature of the processing operation. And we do not go so far as to say that a person's opt-in must be treated as valid even where the controller has before it completely overwhelming evidence that that person is insane, let's say. We don't go
Well, that's an extreme example, but thinking it in the context of the realities of doing business, I think, certainly speaking for myself, and I suspect for my colleagues as well, we would be interested to hear more about a more developed argument in relation to this.
And I'll come to that. And certainly our case is, had we lost on the basis that the court had found that we even knew that RTM was mentally impaired such that he couldn't make free choices around his marketing permissions, well, that is something we ought reasonably to have known in the circumstances, because we ought to have discovered that through the discharge of our safer gambling obligations. In those circumstances, we would have nothing to appeal against, because that would be a lawfully sound judgment, because the court would have approached the consent issue by looking at what the controller either knew or reasonably to have known about the data subject's mental condition at the time they opted in.
The question raised by the language of the data protection, well, all these measures, is whether the consent was freely given, not whether the data controller knew or ought to have known that it wasn't.
This is the.
And we would like to say that there's a burden of proof on the data controller in relation to all these matters. But what has to be proven?
Well, that's the central issue in the.
Freely given.
Yes. Yes.
Whatever that means.
So
that there's, when you come to it, it seems to me that it'd be interesting to know how those two things, knowledge, actual or constructive, on the part of the data controller, and the issue of whether the consent was freely given, how they interact.
Yes, well, I mean, so that you're not held in suspense, we say that this is a regime that has to be workable and has to operate proportionately. And we say that if you proceed on the basis that the consent concept, as it appears in the data protection legislation, is intended to operate on the basis of what's going on in the mind of a data subject, rather than by reference to what the controller either knew or reasonably to know, then this whole scheme becomes unworkable.
No, we follow, that's your principal argument.
That's our argument in
And
principle.
Certainly, again, speaking for myself, and I think again for my colleagues, consent seems to be at the heart of this. The issue of consent is at the absolutely the heart of this appeal.
It absolutely is. And actually the question
the
that we're
meaning of it
debating
in
now is at the heart of the
Yes.
appeal. So the question really is, does the consent concept work on the basis that the question of whether you have valid consent turns on what's going on in the mind of the data subject at the time that they opt in to receive marketing, which is, we say, how the judge has approached the issue. We say that can't be the right approach because it would render the whole scheme unworkable, produce massively disproportionate results. The alternative a way to approach the concept is to say that when the legislation talks about whether consent is informed, whether it is freely given, whether it is unambiguous, the question that falls to be determined is, in the context of the relationship with the data subject, did it appear, or ought it reasonably to have appeared to the controller that the data subject was informed, that the choice was freely made, and that it was unambiguous in nature. And that really lies at the absolute epicenter of this appeal. And
Once you go down the rabbit hole of the Mental Capacity Act, you've then got to distinguish between capacity to make a decision at all and autonomy to make an unwise decision, which the Mental Capacity Act expressly recognises.
Yes. Well, indeed. And in a sense, this comes to another point that's so important for this appeal, which is, as the court rightly observed, an individual may lack capacity in the sense that they genuinely cannot make choices that you know, reflect their kind of autonomous desires, as compared with a situation where they're, if you like, dealing with conflicting imperatives, and where the decision is autonomous, but perhaps not in their best interest, if you like, judged objectively. And this is one of the great challenges that my client and other gambling services providers face, is that it's very difficult for us to discern whether we're actually dealing with a user who's genuinely not making free choices because they're so disordered that in effect they lack capacity, or whether they're dealing with an individual who is making autonomous choices, maybe you might say not the best decisions in the world, but ultimately our view is that unless our safer gambling obligations are triggered in respect of that individual, such that we must, in accordance with the safer gambling regime, effectively suppress their activities on the platform, then we must, we say, proceed to treat them as autonomous individuals who are making their own choices and living their life in the way that they want to. So this is really at the heart of this appeal, which is, what is the test? We say the test is effectively focused on what the controller either surmised or reasonably to have surmised about the data subject's mental state at the point that they consented.
You say surmised, do you mean knew?
Well, the difficulty is I mean, one can't ever actually know what's going on in the mind of an individual, but you can make reasonable assessments, in effect, of whether that individual is incapable of making free decisions. And that's really what we say the legislation is aimed at. So again, if you had a situation where there was evidence before a controller that showed that actually an individual was not making good decisions, because for whatever reason they were mentally impaired such that they couldn't make genuinely free autonomous decisions, then we'd say in those circumstances we can't demonstrate consent.
This analysis involves a factual inquiry into whether the data subject does or doesn't have impaired ability to make decisions, because you can't have knowledge or constructive knowledge in the abstract. First question, do they have that? Second question, if they don't, does the data controller know the data know?
Yes.
So your approach does involve an inquiry into the subjective reality of the position. It just controls it by adding qualifications. It doesn't matter unless it's known or should be known to the data controller.
So, I mean, that's exactly right. Our position is, it all depends on the circumstances of the particular processing activity, the nature of the risks that the processing poses, if any, to the data subject. But we accept that there may be circumstances, and indeed we accept that this case is a good example, where it's not good enough for a controller potentially just to sit back, accept the consent in circumstances where, for example, as a result of their safer gambling assessment, they can see that actually this individual is a problem gambler such that they need to be taken off the platform.
Well, is the key to it whether on that issue, whether as you said earlier, the safer gambling obligations are triggered?
Yes,
So that's really that point.
absolutely. So
This is not a sort of individual specific absent that area of control.
yes, so always there are going to be questions about whether a controller, because of the particular circumstances of the case, ought not to have relied on the opt-in, effectively because they're getting mixed messages from the data subject. So yes, you've got an opt-in, but on the other hand, you've got a load of data that ought to lead you to conclude that they're a high-risk data subject such that you should suppress marketing to them. But, I mean, the crucial point is, as we shall see from the judgment, the court didn't get into any of this analysis. It didn't find that there was no valid consent in this case because we either knew or reasonably to have surmised that RTM was a problem gambler. That's not how the court decided the case.
I'm sorry that this may reveal I haven't read as much as I wanted to, but in the case there's an issue about fairness, which hasn't been resolved.
Yes.
One possible analysis, looking at this from a great distance, would be that you might have a situation where someone consents. All that they do indicates objectively that they've consented to the use of their data for specified purposes. And yet, because of things that the data controller knows or ought to know, it's not fair to deal with the data in a particular way. So someone does something short of withdrawing the consent, but they communicate some fact that affects the fairness of the processing thereafter. Is that
Absolutely.
another possible analysis?
That's another lens through which you can look at the question of the lawfulness of the processing. So in circumstances where an individual has opted in, so they have consented, but a bit further down the road, the controller starts to discern that in fact they are a problem gambler. In those circumstances, whilst they have valid consent, it may be unfair for the controller to continue sending marketing to that individual.
That's not what you were submitting a few minutes ago when you lumped it all in under the question of consent freely given.
So we approach consent, if you like, we treat consent as an additional safeguard in that sense. So we are not arguing before you that in circumstances where a controller had compelling evidence before it that an individual was, whether they lack capacity in the Mental Health Act sense, or there's sufficient evidence that then, for whatever reason, they're not making free decisions. Maybe the controller knows that the data subject is, operating at the whim of a husband who is coercively controlling her, just to give you one example, and the controller had very powerful evidence of that. We would say in those circumstances, adopting a proportionate approach to the application of this scheme, they won't be able to demonstrate consent because there will be sufficient evidence before them, sufficient information arising in the context of their relationship with the data subject, that they can't, that the opt-ins are not what they appear, and the controller knows that in effect. But that is all an assessment that falls to be undertaken in the context of the controller's relationship with the data subject. And the difficulty with the court's approach, as we've read the judgment, is everything turns on not what we knew or what we reasonably to have surmised about RTM's mental condition, but simply whether he was, in fact, subjectively impaired. And we say that is the wrong approach. So we say, just to finish off these points, that what matters in the context of assessing the validity of the particular consent is, or what was the quality of the consent mechanisms that were offered to users? Were they deficient in the sense that they didn't adequately describe the nature of the processing operation, such that the processing operation, such that the consents can't be said to be informed? Did the consenting mechanism railroad users in some way that would again potentially undermine the notion that the consent was freely given? So that sort of objective analysis of the consent mechanism will typically be the core consideration, though there may be other considerations, again, that pertain to the relationship between the data subject and the controller. We've talked about cases involving potential mental impairment, but there are other cases. You might have a situation, meta platforms would be an example, where a controller operates a dominant market position. That may affect, because it is a structural imbalance in the relationship, that may affect the validity of the consent, and in particular whether the consent was freely given. We know that from the CJAU's judgment on meta platforms. But the crucial point is all of these questions have to be considered in the context of the relationship between the data subject and the controller. They can't simply turn on what is secretly known, in effect, by the data
I mean,
subject.
that on one view, that could be said to be a relatively short point, which is, was the judge right or wrong on that issue?
That's why I said this is a straightforward.
To the legislation.
That's why I say this is actually a straightforward appeal. The issues are actually straightforward. First question, did the judge decide this case applying a subjective test? We say yes. Second, if it did, is that the right approach in the law? We say no, because this test is not subjective. It can't be. And that is our second ground of appeal.
And if you're right about that, ground one falls away.
Well, we say we win on ground one, but obviously we win on ground two. It doesn't really matter which ground we win on either way. The judgment falls to be overturned. But just before we leave ground two, I'm going to come on to ground one in a moment. It's very important that as we read his skeleton, RTM does not seek to argue that the test for consent is subjective, that it can properly rest on what's going on subjectively in the mind of the data subject. Instead, he focuses his efforts on seeking to persuade the court that the judge didn't actually apply a subjective test. So what he seeks to do in his skeleton is persuade you that whilst the judge quite properly took into account RTM's mental condition as in effect being contextually relevant, ultimately, he says, she decided the consent issue by reference to essentially objective factors concerning the general adequacy of our consent mechanisms. The difficulty for RTM, as we should come on to see when we look at the judgment, is that is simply not how the court decided the case on consent. If we win on this point, it seems to us that RTM simply has no answer to our ground two, and that accordingly I must succeed. Then our third point in outline is we say, quite apart from the fundamentally erroneous nature of the court's reasoning on the consent issue, the judgment can't stand because it decides the consent issue on a basis that wasn't argued for by any party appearing before it at any time during this trial process. That is our ground one. Again, we say the points under this ground are straightforward. At no point in the litigation process was RTM's case mounted on the basis that he did not validly consent to receive direct marketing because he was at the time subjectively suffering from a mental impairment by reason of his gambling disorder. It was never his case before the court that he did not validly consent because he was subjectively mentally afflicted. No case of that kind was put in RTM's pleadings. No case of that kind was put in RTM's written arguments before the court. That case was also not put in Malone and Friends' oral arguments before the court, both in advance, both in opening or indeed in closing arguments after RTM had given his evidence. Instead, as we shall see, RTM's case on consent proceeded on the entirely orthodox, conventional basis that he didn't validly consent to receive direct marketing from my client, either because he didn't physically opt in to receiving direct marketing, or because even if he did opt in, our consent mechanisms were objectively not up to scratch, such that we couldn't show that the consents we obtained through those mechanisms were valid. And it's important to note in this context that RTM's decision to focus on these sorts of objective considerations rather than on his subjective state of mind was taken with the benefit of expert advice given to him by his legal advisors who, it must be said, are of the very highest calibre. And indeed, in his skeleton for trial, RTM went so far as to describe the debate about his self-description as a gambling addict as being of limited legal relevance. We see that in paragraph 5 of his skeleton, which is in the supplemental bundle at page 215. Just to pull that paragraph up, if I may, because it really does give you the flavour of the way RTM is approaching the issue of his mental condition. So it's the supplemental bundle, page 215, tab 14. I'll just ask you to read that paragraph, please.
Which paragraph did you say?
Paragraph 5.
5. Yes, thank you.
So what we see from this paragraph is RTM making clear that when it comes to liability, his gambling disorder is pretty much by the by. What matters, he says, is that his consent effectively wasn't informed because of inadequacies in our transparency materials. He says that resulted in unlawful processing and unlawful direct marketing, and that those activities in turn fueled his disorder, which is relevant to his case on damage. That is reflective of the position that RTM took across the board in the case that he presented before the court. And yet, as we shall come on to see, the claimant's subjective mental condition is treated in the judgment as being not only relevant to the case on consent, but the decisive consideration. And in effect, what has happened in this case is the court has invented a case on consent based on RTM's subjective mental condition, and then proceeded to decide the consent issue against us based on that invented case, despite the fact that that case was never mentioned or even vaguely endorsed by RTM, and indeed despite the fact that the court never put this invented case to the parties, or certainly not in any meaningful way. We say that is straightforwardly unjust and wrong, and so for that reason too, the judgment cannot stand. And it's these matters together that really, we say, lie at the heart of the appeal. And I want to emphasise at the outset that it's very much these matters that motivated my client's decision to appeal against the judgment. My client takes the view that it is fundamentally wrong and unjust that the court decided the case on consent based on a case that was never put by RTM. It also takes the view that the court has landed on a test for consent that is fundamentally unprincipled and unworkable, causing major issues for my client's wider data processing and direct marketing activities. And that is why my client has brought this appeal.
Well,
Turning to
if on your case, it would affect others as well
Absolutely.
who process data,
It-
because the question of consent is material whenever data is processed.
Absolutely. And that is obviously something that must be borne in mind when we're considering the judgment in due course. Just turning to the Commissioner's intervention, we're of course immensely grateful to the Commissioner for his very careful and considered submissions. As you'll have seen, those submissions firmly and comprehensively support our appeal on ground 2. We say that it's particularly striking that the Commissioner has intervened in our appeal in order to robustly support our case on ground 2, not least in view of the trenchant criticisms made of my client's attempts to appeal this judgment that are comprised within the court's refusal of permission to appeal, which is in tab 6 of the court bundle. It's clear from its submissions that the Commissioner is deeply concerned about this judgment, specifically on the basis that it effectively serves to upend the careful, balanced and proportionate approach to data protection which the underlying legislative schemes is designed to achieve. We say the Commissioner's concerns are manifestly justified. Consent is a centrally important concept, both within the data protection regime and within PECA. This judgment adopts an approach to consent which is completely absolutist in nature and cashes out in a form of strict liability for the controller, rendering their conduct unlawful, no matter how reasonable and responsible they have sought to be in their dealings with the data subject. We say that is wrong, and so does the expert regulator. As you may have seen from our written submissions in response to the Commissioner's submissions, we say that submissions made by an expert regulator on the law it is charged to uphold ought to carry considerable weight with this court. For your notes, we make this point at paragraph 3 of our responsive submissions, in which we refer to the relevant authorities. It's page 290 of the core bundle. And I note that RTM has not rowed against that proposition in his own responsive submissions. It's a proposition we invite you to accept. I pause there to note that in his response to the Commission's submissions, RTM asserts that the Commissioner is not an expert when it comes to gambling regulation, mental capacity, tort law or contract law. This is an assertion that doesn't avail RTM for the simple reason that the ICO's core submissions fundamentally concern the operation of the legislative regimes for which it is responsible in law, namely the data protection legislation and PECA. As we see it, the ICO is not at any point through its submissions seeking to move the legal dial when it comes to gambling regulation, mental capacity, tort law or contract law. Its submissions instead remain firmly in the wheelhouse of the legislation in respect of which it is expert. I'll leave it to Ms. Emerson to develop these points to the extent she feels she needs to. And we do wish to underline in this introductory section of our submissions that this is a judgment which, because of its strict liability approach to consent, really does have draconian implications for all controllers who, like my client, engage in consent-based processing which may pose a risk to data subjects, and who want to ensure that they are at all times conducting themselves compliantly and in accordance with the law. As we see it, the net effect of this judgment is that we cannot construct a regime whereby we can comprehensively, lawfully direct market to our users. And that is because, as the court has expressly acknowledged at paragraph 181 of the judgment, no matter how robust our safer gambling mechanisms or our approach to marketing consents, there will always be what the court refers to as that irreducible, ineradicable minimum of users whose judgments will be subjectively impaired such that on the court's approach they cannot validly consent to receive direct marketing. This has the inevitable result that with the best will in the world, we simply cannot design and operate a direct marketing regime that is comprehensively compliant and lawful. On the court's approach, and as it effectively explicitly acknowledges in the judgment, however we construct our regime, we simply cannot contrive matters so as to be able to demonstrate valid consent across the totality of that cohort of users who've opted in to receiving direct marketing. And that is a major problem for my client, and we would say likely for many other controllers, because we are a responsible service provider. And we want to ensure that we are consistently saying the right side of the law, whether in the field of safer gambling, the field of data protection, PECA, or more generally. Staying within the four corners of the law really matters to us, as of course it should. And by the same token, this judgment is bound to be a major problem for all other responsible controllers engaged in consent-based processing, particularly where that processing may pose a risk to some proportion of data subjects who may use its services. I'm going to explain in due course why we say the court is wrong to suggest, as it does in its reasons for refusing permission to appeal, that all of these concerns, all of our objections to the judgment are effectively answered by Regulation 30(2) of PECA. the court makes that point in the N260 reasons, which you'll find in tab 6 at page 123. In summary, what we say about that provision, which we'll come on to look at in due course, is first of all, it affords no defence to claims brought under to claims brought under the GDPR. Moreover, in any event, it doesn't serve to render lawful that which the court has said must be treated as being unlawful, illegal. It merely creates a defence to a civil claim for damages. What that means is we will still be left grappling with the illegality problem. And I pause there to note that it is particularly unfortunate and unfair that the court has chosen to criticise my client for not invoking this defence, given that it's a defence that could only have been relevant in circumstances where RTM had relied on the fact of his gambling disorder and its impact on his subjective mental condition in support of his case on consent, which is something he did not do. And just to complete our outline analysis of our case, of the remaining grounds, grounds 3 and 4 concern factual findings made by the court. Ground 3 proceeds essentially on the following basis. If and insofar as the court held that there was no consent in respect of the pre-GDPR period, because contrary to our case, RTM did not physically opt in to receiving direct marketing communications, which we say he did on the 26th of July 2017 by changing his marketing preferences. If the court found that, in fact, RTM did not opt in to receive direct marketing at that point, then we say that that finding was legally wrong. First, because it rested on the application of the wrong standard of proof, and second, because there was in any event no proper basis for it, having regard to the evidence that was before the court. And I pause there to note that whilst we do challenge this aspect of the judgment, because we do say it is fundamentally flawed, had my client merely lost on that point, we would not have appealed this judgment, because it concerns sui generis historic matters relating to a single individual. It doesn't pose the systemic threat that the wider aspects of the judgment poses. And that's why I plan to deal with ground 3 at the very end of my submissions. Ground 4 concerns the court's finding in paragraph 205 of the judgment that our cookie placement activities enabled the personalisation of the direct marketing communications that we sent to RTM. We say the court had no proper basis for drawing that conclusion in view of the evidence before it as the role played by cookies in our marketing operation. And then finally, ground 5. This ground concerns the court's findings, also in paragraph 205, that because we lose on consent, we also lose on our legitimate interest case concerning our internal processing operations. Self-evidently, because that finding is parasitic on the court's finding on consent, if we win on ground 1 or ground 2, then that finding necessarily falls away, given its parasitic nature, and so our ground 5 would succeed on that basis. But we also say that the finding is in any event erroneous, because it's based on a concession we didn't in fact make, which is, we say, evident from a straightforward reading of the relevant exchange in the transcript. Having set out our case in outline, I'm keen now to turn to the legislative framework, but before I do so, and just for good order, I wish to confirm that we gratefully adopt all of the ICO's very helpful submissions, subject to one point. In paragraph 51 of their submissions, the ICO seeks to argue in favour of a particular test for deciding whether or not personal data amounts to special category data for the purposes of Article 9.1. We don't agree with how the ICO has framed the test, essentially on the basis because we think it sets the threshold too low. But I don't propose to address you further on that very narrow point. First, because the issue of what qualifies as special category data is not before this court. Second, because we can't see that this court is going to be assisted by a rabbit hole dispute on the issue of what qualifies as special category data. And third, because following discussions with the ICO on these matters, we understand that the ICO does not propose to press that part of its submissions in its oral submissions before you today. So turning then to the legislative framework, there are actually 4 regimes that we need to examine. They are the Data Protection Act 98, the GDPR, HECA, and the safer gambling regime provided for under the Gambling Act. I propose to begin with the GDPR. I'll then deal very briefly with the DPA 98. I'll be brief on the DPA essentially because to the extent that it differs from the GDPR regime, those differences are, we say, immaterial for the purposes of this appeal. I'll then address the court on the PECA regime before finally turning to address you on the Gambling Act safer gambling regime. So then we start with the GDPR, and I'd asked you to consider the version that we handed up this morning. That's a bit more comprehensive and fulsome than the version that's in the authorities bundle. So I'm looking at the version that starts at page 1167. Before we look at this regime in detail, I'm keen to make some overarching submissions about the objectives and design of this legislation. First, it is of course right that under the GDPR, it is of course right that the GDPR is concerned fundamentally with safeguarding privacy rights of individuals. That is undoubtedly a core objective of this legislation. But importantly, it is not its only objective. As we shall see, the regulation is also intended to achieve other goals, including not least contributing to economic and social progress and safeguarding fundamental rights in the round. Second, and relatedly, this legislation is, we say, designed and intended to be fundamentally non-absolutist in its approach to data protection. The legislation does not aim to ensure that privacy and personal autonomy is protected absolutely, no matter the circumstances or the cost. Instead, this is legislation that consistently aims to achieve a balanced and proportionate approach to data protection, with the imperative to protect privacy and personal autonomy in that sense being held in a firm balance with competing legitimate imperatives and indeed with competing fundamental rights, including, where relevant, the competing Article 10 right to free expression. Third, and on effectively the same point, the principle of proportionality looms large over this regime, governing how the regime is to be construed and applied. Fourth, consistent with all of these points, we say it is simply not possible to construe this scheme as creating forms of liability which are essentially strict in nature, such that controllers should be held liable based on matters which are realistically outside of their knowledge or control. Controller concept itself implicitly carrying within it the notion that controllers are responsible for that which they can control, not that which is beyond their control and indeed beyond their knowledge. Fifth, relatedly, the focus of this legislation is essentially on what can reasonably and proportionately be expected of the controller in all the circumstances. This is not legislation which in effect expects controllers to achieve the impossible, or indeed to have an oracular understanding of what might be going on behind the scenes with the data subject. Sixth, and coming back to the issue of personal autonomy, I'm keen to emphasise that, of course, the protection of personal autonomy is not a monolithic thing. It can, of course, be about safeguarding people from things which may be harmful to them, for example, because it trespasses on their privacy. But importantly, the protection of personal autonomy is also necessarily about respecting the individual's choices as to how they want to live and experience the world. Now, as to that, the consent principle is an important principle within the GDPR regime, not only because it gives the controller a route to the lawful processing of personal data, but also because it gives the data subject the ability to authorise a form of data processing which they may positively welcome and want to happen. It is a principle that thus performs a dual role, protecting the interests of the controller and potentially wider interests, but also protecting the personal autonomy of data subjects by giving them the ability to enable processing that they positively want to take place, whether because they think it will serve their own interests or because they think it will serve wider societal interests. Take the example of direct marketing. There is, of course, a commercial benefit to businesses which engage in direct marketing, and by extension, there's a benefit to the economy more widely. But at the same time, individuals may want to receive direct marketing because they're interested in purchasing the relevant goods and services, or because they think they can, by that route, gain access to valuable offers from which they wish to benefit. By opting in to direct marketing, the individual is in this context exercising their personal autonomy, and indeed they are doing so in the context of the exercise of their fundamental Article 10 rights. Those rights, of course, include the right to receive information. I make those points because as we look at the legislative scheme and how it approaches the consent concept, it's important to remember that when it comes to data processing, the benefits don't necessarily only flow towards the controller. They can and often do flow towards the data subject. That is true in the context of direct marketing, as it is in other contexts. And these points are important because they underline that if the bar is set too high when it comes to consent, that is something that may positively thwart the protection of the very personal autonomy at which the legislation is aimed. If the controller is forced to second guess what appears on the face of things to be a clear, unambiguous, freely given and informed choice made by the data subject, not only may that have bad outcomes for the controller, it is also likely to have bad outcomes from the data subjects, resulting in a situation in which their autonomous choices are not being respected. And we say those points apply with particular force, whereas here, Article 10 rights are engaged. So the short points are, setting impossibly high consent standards under the GDPR is bound impermissibly to produce unbalanced and disproportionate results, results that cut across the personal autonomy and Article 10 rights of the data subjects themselves. And we say that is simply not an outcome which the legislators can be taken to have intended. And it's important that I underline here that if we cannot direct market to our millions of users because we cannot erect an effectively compliant direct marketing regime, that is something that substantially undermines not only our commercial interests and indeed our Article 10 rights, but also the Article 10 rights of all our millions of users who are gambling safely and in the absence of any impairing disorder. And again, we say that cannot be the right result. So having made those overarching submissions, I'm keen now to take you through the legislation itself. Can we begin, please, by the court reading the first 4 recitals, which will give you a strong flavour of the ultimate objects. Note in particular recital 2, the objects include protection of personal data and contributing to economic and social progress. Note 2, recital 4, which underlines that the right to data protection is not absolute and that it's a right that falls to be held in a balance with other countervailing rights and interests. See further that the recital makes clear that the regulation seeks to respect all fundamental rights, including a freedom of expression and information and the freedom to conduct a business. C2, the express reference to the principle of proportionality, which is clearly intended to govern the operation of this scheme and across all issues. As for the broad structure of the legislation, the key definitions are in Article 4, which is page 1174.
We need to pause at recital 32.
I'm going to come back to that recital, if I may. Just want to give you a sense of the structure of the thing, and then we'll come back to the material recitals around consent. So Article 4, the definitions that the court should cast its eye over include, we say, the following. First of all, the definition of personal data in Article 4.1. Second, the definition of processing in 4.2. Third, the definition of profiling in 4.4. Fourth, the definition of a controller in 4.7. Fifth, the definition of a processor in 4.8. And then crucially, the definition of consent in 4.11. As we see it, Article 4.11 proceeds on the basis that the following requirements must be made must be met for valid consent to be established. First, there must be an indication by clear affirmative action that the individual agrees to the processing. Second, that indication must be freely given. Third, that indication must be informed. And fourth, that indication must be ambiguous. Now, pausing there, I'm so sorry.
Unambiguous, I think.
Unambiguous, apologies.
You missed out specific.
Yes, I mean, we see that as a sort of tied, let me just bring up the extract as a tied element. And of course, this case is not about whether our consent was sufficiently, our consent mechanism had sufficient specificity. Now, pausing there, RTM seeks to argue, following the judgment of the Upper Tribunal and Leave EU and ICO, that the Article 411 test for consent sets a relatively high bar, because that was the language used by the Upper Tribunal in Leave EU. The relevant paragraphs, paragraph 51 of the judgment. Now, if what RTM means by that is that there are quite a few hurdles that must be cleared to establish valid consent for the purposes of the GDPR, we wouldn't demur. On the other hand, if he's seeking to suggest that Article 411 is to be construed narrowly or strictly against the controller, we would very much demur, not least because, as I sought to explain, the consenting process is something which can enable personal autonomy as much as it may serve the interests of the controller. And for your notes, in Meta platforms, the CJU made a point of saying that the other lawful bases, other than consent, fell to be construed restrictively. There's no suggestion that the same holds true in respect of consent under Article 6.1a, the relevant paragraphs are paragraphs 92 to 93 of that judgment. I'm going to say more on the authorities on consent in the next section of my submission. So then next we turn to Article 5. Here we have the data protection principles. If you cast your eyes over Article 5, you'll see that the duties are wide-ranging and onerous. The key principle for present purposes is, of course, Article 5.1a. Data must be processed lawfully, fairly, and in a transparent manner. Though I'd also ask you to note the security duty in Article 5.1f. Note in particular that the requirement is to apply appropriate security measures to ensure appropriate security, not to guarantee the security of the data absolutely. 5.2 is important. The controller must be able to demonstrate compliance with the principles. Thus, it must be able to demonstrate it is processing data lawfully, fairly, and transparently for the purposes of Article 5.1a. So we see that the scheme not only imposes a wide range of onerous compliance obligations on the controller, but it also places the burden on the controller to ensure it can demonstrate it has achieved compliance in practice. Now, needless to say, but if compliance depends on something which is essentially outside the knowledge of the controller, whether actual or constructive, if it is not something that the controller knows or is reasonably discoverable by the controller, then it will be categorically impossible for the controller to fulfil its obligations under Article 5.2. Indeed, on that approach to consent, if it can rely on matters that aren't knowable in effect by the controller itself won't even know whether it's complied with its obligations or not. Maybe it will have, maybe it won't have. The controller is left guessing, with the situation only becoming clear after the event when faced with a complaint or a legal claim. We say that would self-evidently be a very strange and indeed impossible state of affairs. We say it's not one that the legislators can possibly have been contemplating when they enacted this legislation, not least because it so profoundly conflicts with the imperative to achieve legal certainty and also the imperative to achieve proportionate results. Turning back to Article 5.1a, the lawfulness component of 5.1a falls to be read together with Article 6. Article 6 sets out the lawful bases for processing personal data. It makes clear that processing shall only be lawful to the extent that one or more bases apply. As you'll see, consent is the first lawful basis. But note 2, Article 6(1)(f) concerning processing on grounds of legitimate interest. That's the basis that we relied on in respect of our internal marketing-related processing. I just want to pause there in order to refer you to a recital concerning the legitimate interest basis, which is not actually, unfortunately, in the extract from the GDPR that's before you, but is cited in Meta Platforms. The relevant page is page 790 of the authorities bundle. The relevant recital that I'm keen that the court looks at is recital 47, which you'll find at the bottom of page 790. The sentence is the final sentence. The processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest. We suggest the reason that direct marketing is specifically called out in this way in the recitals is in order to underline that, generally speaking, direct marketing is an activity that amounts to a societal good, not least because it's central to driving forward our market economy and hence achieving economic progress for the benefit of all, and because it is something that the individuals themselves may want to receive. And the simple point is that the legitimate interest basis exists in part to enable activity of that nature to be undertaken, notwithstanding that it may have impacts on data protection rights. Going back to the operative provisions of the GDPR, next we have Article 7, which is page 1181 of your extract. As you can see from the heading, this article is concerned with identifying the conditions for consent. 7.1, we see there is an express duty to demonstrate consent, which is obviously lex specialis to the duty provided for in Article 5.2. Again, this provision necessarily presupposes that controllers are practically in a position to both discern and evidentially prove all factual matters relevant to whether consent has been given. And that's important because when it comes to an individual's subjective state of mind, that is something which ultimately can only be known by that person. And that's, of course, typically why parties to litigation plead to an alleged state of mind by way of a non-admission. Whatever they may surmise as to what's been going on in the mind of the individual, ultimately they don't and can't know. Only that individual can know. Here already we see the deep illogic of supposing that the test for consent could to any extent depend on what was going on subjectively in the mind of the data subject, as opposed to on matters that are effectively manifest in the relationship between controller and data subject, or ought to be manifest, such that they ought to be discernible by the controller. We say that this provision alone suggests that consent cannot turn on matters which are by their nature beyond the controller's ken. And it shows, we say, that the test for consent must be directed at what judged objectively the controller either surmised or ought to have surmised as to whether the consent was freely given, informed, and unambiguous. Article 7.2 is concerned to ensure that consent requests made by the controller are not effectively buried, so as to create a risk that the data subject won't understand what they're signing up for. Article 7.3 concerns the right to withdraw consent. The way in which Article 7.3 is framed makes clear that, in effect, once given, consent subsists until it's withdrawn. Then 7.4, this provision specifically concerns the freely given element of the definition. It's aimed at ensuring that in the context of their relationship with the data subject, controllers are not themselves limiting the data subject's freedom of choice by suggesting that they'll be deprived of particular goods or services if they don't consent to the processing. We see here the focus is firmly on the relationship between the controller and the data subject, and making sure the controller doesn't structure the consent process so as to ensure, in effect, that the choice made is not a free one. Article 8 is all...
Pause there. The language of Article 7.4 is utmost account shall be taken. Do we have any guidance on what that actually means?
I don't believe we do.
Some form of emphasis.
Yes, yes. This is really placing the burden on controllers to make sure that their consent mechanisms don't skew the decision in a way that's not tenable.
Yeah, it looks a bit like strictly necessary in other contexts.
Yes.
Which just means necessary.
I can't really assist on why that language is used, but the critical point for the purposes of our argument is it's focused on the relationship between the parties and what can reasonably be expected. What can reasonably be expected of the controller in the circumstances? Article 8 is also worth noting. Article 8 embodies a number of provisions aimed essentially at safeguarding the interests of young children in the context of the provision of information society services, ISSs. ISSs include, for example, social media platforms, search services, and the like. For your notes, the definition of an ISS is in Article 425 of the GDPR. That definition links to a definition in a separate EU directive, which we have copies of if the court would like to see it. But essentially, it's platforms, search engines.
Yeah, I would like to see it.
Of course. Well, we'll hand it up. So in a nutshell, Article 8 proceeds on the basis that where consent is relied on by the ISS as a relevant lawful basis for the particular processing, and the service user is under the age of 13, i.e. they're an underage child, then Article 8 requires that the controller obtain parental consent for the processing. In effect, in order for the consent to be valid, it must be parental consent. Now, a number of points on this provision. First, it was plainly enacted to safeguard the rights of a cohort of data subjects who are inherently, intrinsically vulnerable by reason of their youth. Second, the guidance on this provision notably proceeds on the basis that it bites, in effect, where the controller ought reasonably to have identified that the user was underage, using appropriate age assurance measures. And that it doesn't therefore bite simply by reference to the user's actual age. For your notes, the relevant section of the guidance is, first of all, the EDPB guidance, where the EDPB deals with the issue. It's at paragraphs 132 to 133 of the guidance, which is at page 950. In the authorities bundle, it's tab 35, page 950. And we see a similar approach emerging in the ICO's guidance, which is at tab 36, page 986.
So how does this work? The controller makes reasonable efforts to verify that consent is given by the holder of parental responsibility.
So,
and despite those reasonable efforts, it actually turns out that consent has not been given by somebody with parental responsibility. Is that lawful or not lawful?
there's no breach of Article 8 in those circumstances. So actually there are two stages of kind of reasonable efforts. One, you have to make reasonable efforts to ascertain whether your users are underage, so that you're in a position reasonably to identify whether they're underage children or not. And then at the second stage, if you've identified using your age assurance measures that they're underage, then the obligation falls on you to make reasonable efforts in effect to secure parental consent. You don't have to guarantee absolutely that the consent that you have came from the person who was the parent of that child.
If you've made reasonable efforts to carry out an age check, but it actually turns out that the user of the service is 15, you're not right.
Yes. So if they're 11, let's say, but you've got age assurance measures in place that are appropriate in all circumstances to identify underage users, you know, again, this is not legislation that requires controllers to achieve the impossible. So this reasonable efforts consideration applies both at the stage when you're working out whether someone's underage or not, and also at the stage when you're trying to work out whether you've got parental consent or not.
Now, your analysis, and I think that of the ICO, there's another level at which the validity of the consent of the parent has to be considered in the light of what is known or ought to be known to the data controller. Exactly.
I mean, that's the function of the provision in Article 8, Article 8.2. The expectation, again, we come back to the point that this legislation does not require controllers to achieve the impossible. It requires them to act reasonably and responsibly. So what we see in the context of Article 8 is that in respect of a cohort that is intrinsically vulnerable, at risk, there is no absolute protection for that cohort. There is no absolute guarantee or absolute requirement that the guardian has in fact consented. And we say that's very important because if the test isn't absolute in respect of a cohort that is necessarily vulnerable and at risk, how can it possibly be right that it becomes absolute and strict generally in the context of consent under Article 6.1a? And Article 9, just briefly, Article 9 embodies specific protections in respect to special
Can
category.
you just remind me, I know you're going to go through the judgment in detail, I'm sorry to interrupt, was this article referred to in the judge's judgment or in the course of argument?
Article 8 wasn't referred to in the judgment, but I remind the court it was never put to us.
No, I understand,
So
I understand that, yes.
we haven't had, this is the first time we have the opportunity to address any court on the question of whether the subjective test is the right test. So Article 9 then is concerned with specific protections in respect of special category data. Definition of special category data is in 9.1. It includes, for example, data concerning a person's sexual life or their health. Article 9.1 provides that the processing of such data is altogether prohibited. But then 9.2 disapplies that prohibition where one of the gateway tests identified are met. And you'll see from 9.2a that explicit consent is the first gateway. So the consent principles also relevant to the processing of special category data. Just to touch briefly on Article 32, which is lex specialis to Article 5.1f. This concerns the security usage.
Where are you going now?
So it's Article 32, it's page 1184 of the extract. So here too, we see the legislature adopting a fundamentally non-absolutist approach. What's required under Article 32 is that the controller applies appropriate measures to ensure a level of security appropriate to the risk, not to guarantee absolutely that the data is secure, apart from anything else, because that is practically unachievable in the world in which we inhabit. So again, we see that this is legislation that's seeking to achieve a balanced, proportionate approach to data protection that is fundamentally non-strict, non-absolutist. Just coming back to the recitals, my Lord mentioned recital 32, that's at page 1161 of the extract. And apologies, it's not, it's paragraph, it's page 1169 of the extract. Just invite you to cast your eye over that recital. And also, if I may, recital 42. Also, please, recital 43.
One of the interesting things about recital 32 and the language of the body of the GDPR is that consent consists of an act.
Yes.
An indication.
Yes.
It has to have certain qualities.
Yes.
But recital 32 tells us that in the middle, this could include ticking a box. And that ticking pre-tick boxes should not constitute consent. So it looks like consent is, on the face of it, defined as an act
I'm so sorry.
Yeah, no,
You know, I'm so
I
sorry.
understand.
I'm so sorry.
Do you want to read the note before you?
Well, it's been suggested
before
that the
you reply?
transcriber may need a break.
Yes.
All right. So, yes, it's nearly 10 to, so we'll sit again at midday. Thank you very much.
All right, able.
It's not a mark.
No, I have a number of other clients that are very happy with their nice noises about that person. Just some possibilities. I think it's right. It's right. Most things people do is how to try it. So incredible.
Don't worry, it'll be much worse by the end of the afternoon.
I don't know, because I've got my first night on the open bank, because I've got people who's chilling. Chilling in the right sense, let's say. Oh, do you want to just hand on the
Just so you know, that's one.
Yeah. I'll take that out.
It's not a rush, but it's easy to do.
Well, so yeah, that's exactly it.
That's right. We have to try and just start.
We've got enough.
Always happy to have some extra directives.
Oh, absolutely, can't do that.
This should be exactly should control the whole.
Yeah.
Yeah. How's going? Just trying to go good specific.
Oh, yes. Yeah.
Very interesting. This is
Right,
right.
Yeah, try higher. Yeah.
Yeah, I see that.
It's trying to find somebody that's technical, model level, governance, compliance, risk.
And there's anything else. I thought AI. Just absolutely. It doesn't have the potential to take over the world.
Yeah, exactly. Yeah. Sarah Connor.
Are you preparing for this?
Strange old ones at the minute. New phones. Big one this weekend. Chris, that's just the directive that the judge wants to see. No one does. There you go.
I've got two.
I had to keep bringing it
Couldn't swing lost.
What else do you need?
It's not been too bad. I don't know. Well, I appreciate we are.
Before we broke, I was just raising a point about recital 32 on our page 1169, and the relevant language of the body of the GDPR, both of which seem to identify consent as being, not as evidenced by, but as being an indication.
Well, it has to be a certain kind of
Yes,
indication.
an indication with the qualities that you enumerated. I think you and the ICO both focus in on the single quality that seems, for my part, to be the most relevant, freely given. But it might be said, on the face of the language of the GDPR, freely given is a quality that the Act has, not a quality that is extraneous to the Act. In the context, as you point out, it's got to be contextual. So that one doesn't see an obvious indication in the language there that we've got to delve into what the data controller knows or ought to know, which is something
So it's one or the
that
other.
is a responsibility of the data controller under Article 9.
So it seems to us it's one or the other. Either the test rests on what's going on behind the scenes, effectively, so far as the controller is concerned, in the data subject's mind, that could be affected by all sorts of factors, not just incapacity, but other considerations, coercive husbands, all sorts of things that may affect whether someone is subjectively freely consenting, or whether that is not a workable approach to the concept of consent. So you judge it from the perspective of the controller, but not resting at simply what they knew, but also what they ought reasonably to know in all the circumstances.
Going back to my Lord's point in relation to the Act and freely given, might Article 7.4 be relevant here? One reads it in that context, which is whether it's conditional on consent.
Yes.
So, for example, one sees that if you can only get this service if you consent to X, Y, or Z, that's the sort of issue that might arise in that context.
Yes, so if the controller is effectively itself erecting barriers to the choice being free, so it's constraining the choice in a way that effectively becomes non-free, then that is going to cause difficulties for the controller in terms of being able to demonstrate consent. But the critical point is that's something that arises in the context of the relationship, as does the next point that I was going to come on to, which arises out of recital 43, which I'd ask you to read if you haven't done so already.
Just before we get there, can I ask you about the relationship between Article 6.1a, which says it's lawful to process data if the data subject is given consent, and that obviously means consent as defined.
Yes.
And then Article 9, this applies Article 9.1. If the data subject has given explicit consent, what's the difference?
So,
Given that consent itself has to be specific.
well, that's a very good question, and there's actually been a lot of debate around what, now that we're in the GDPR world where the whole approach to consent has changed, what explicit actually adds. And I think there's some complexity as to what it does add, if anything, because the whole point about an affirmative action is by its nature explicit. So, I mean, all I can say is that we're not sure it adds a great deal, but that language was in the predecessor legislation where arguably the test of consent was somewhat weaker, though not we say in ways that are particularly relevant.
It's a bit like the phrase strictly necessary.
Exactly. It's just emphasising the importance, and I guess if there's any room for doubt, it's resolved against the controller. So then on recital 43, this highlights that consent may not be given where there is, to use the language in that recital, a clear imbalance. As may be the case, the recital says, where the controller is a public authority. That language of clear imbalance is, we say, important. It reflects not only the fact that there needs to be an imbalance, but that the imbalance needs to be discernible. We would say it must be discernible to the controller at the very least. We say there can be no clear imbalance merely as a result of something that is secret and known only to the data subject. See also the second half of recital 43, which lands on the ways in which the controller can by its own actions, again, thwart the achievement of valid consent in the context of their relationship with the data subject. See too also recital 58, the following page, which concerns the transparency requirement in Article 5.1a. Note that recital doesn't proceed on the basis that transparency means that the data subject must have actually read, digested and cognised the contents of a privacy policy, such that they are subjectively fully cognizant of every aspect of the processing. Instead, it simply proceeds on the basis that the controller must craft its privacy policy so as to ensure that by its nature it can be readily understood should the data subject choose to read it. And that's important because we say there's no logical basis for contending that subjectivity doesn't matter in the context of transparency under Article 5.1a, but does matter and indeed is critical in the context of the lawfulness requirement rather than 5.1a. Surely the approach must be the same across both of these elements. We make the same point in respect to the fairness element of 5.1a. As to that, it's well established that fairness isn't to be judged subjectively, merely from the perspective of the data subject. Instead, it's to be assessed objectively, reflecting the balance of interest between the controller and the data subject. See further paragraph 37, the judgment of Miss Justice Swift in Dale and Vince at page 460 of the authorities bundle. And again, there's simply no good reason why a different, stricter approach should be adopted in the context of the lawfulness requirement as compared with the fairness and transparency requirements. Moving on to enforcement under the GDPR, as you'll know, of course, the ICO plays an important role in enforcing the obligations provided for under the Act. The relevant provision is Article 58.2. It's not in the bundle, but I believe we have a copy if you'd like to see it. And I should add that the directive that the court asked to see in terms of the definition of an information society service is before the court. We handed it up over the break. Then in addition, in terms of enforcement of rights under the GDPR, we have to look at Article 82. Article 82 creates a form of civil liability for the data subject, enabling them to bring damages claims where they have suffered damage as a result of an infringement.
Where do you want us to find that?
So that is in the additional mini bundle. It's at page 1185. you'll see H21 provides that an infringement that's caused damage is compensable. 82.2 provides that any controller who's involved in the relevant processing shall be liable for the damage caused by the infringement. But that provision has to be read subject to Article 82.3, which creates an exemption from that liability where the controller or processor, as the case may be, proves that they are not in any way responsible for the event giving rise to the damage. Now, I don't believe anyone's suggesting that that provision could have operated as a defence in the instant claim, but in case it assists, we say that this is a provision that is concerned with a situation where you have a range of potential tortfeasors, and the question is who should be imputed with liability. So you might have that situation, for example, where you had a processing operation where you had joint controllers responsible for the relevant operation. You might also have that situation where you had a controller, but also a processor who is processing data on behalf of the controller. In those circumstances, what Article 82.3 seeks to do is to ensure that a controller or processor, as the case may be, will be off the liability hook if in effect they were in no way responsible for the event that caused the damage, because all responsibility for that event sits, if you like, with the other controller or with the processor. But where there's only one controller and no other controllers or processors on the field, there's simply going to be no one else to whom liability can be imputed under Article 82.3. So the exemption can't bite. And that's very important because what it means is that were consent to be treated as being invalid by reference to the data subject's state of mind, something that the controller couldn't have known about in the circumstances, the controller would have no defence at all under the GDPR to any claims for compensation because they would be the entity that was responsible for the event that caused the damage, and so couldn't rely on Article 82.3. So, for example, if a controller relied on consent in order to share personal data with a third party, but that consent felt to be treated as invalid because of the subjective state of mind of the data subject, the controller would have no defence under the GDPR to a claim for damages brought in respect of that processing, no matter that on the facts there was literally nothing they could have done to ascertain the data subject's state of mind. We say that is necessarily wrong and not the result this legislation was aimed at. And I should say that all of these points were ignored by the judge in the context of her approach to consent under the GDPR. And I should say that even if Article 82.3 could be read as somehow creating a defence for the controller in those circumstances, that would not solve the underlying illegality problem, which is a problem for all controllers that want to act lawfully in the context of their processing operations. May mean they're not liable for damages in a particular instance, but it wouldn't render their processing lawful, which is a problem if you're a responsible controller. All the more reason then to conclude that consent can't turn on the subjective state of mind of the data subject because it would produce such impossibly unfair and disproportionate results. And the question has to be asked, what's the point of an approach to consent which cashes out in a controller having acted unlawfully by reason of the data subject's secret mental impairment, but in it then being able to avoid liability under Article 82.3 by reason of the very same secret mental impairment? Logic and common sense dictates that such secret matters should not vitiate the validity of the consent which has been given in the first place. Now, just before we leave the GDPR, I just invite you to look at Article 95, which deals with the interplay between data protection legislation and the directive, the Privacy Electronic Communications Directive, under which PECA was enacted. It's at page 1187. The effect of this provision, in short, is that where the GDPR and the PEC directive effectively cover the same ground, the GDPR does not impose additional obligations beyond those provided for in the PEC directive. So in those circumstances, in effect, the GDPR obligations that would otherwise apply don't apply. And clearly the aim of this provision is to avoid dual obligations arising in respect to the same activity. So what that means, for example, is if you're dealing with a direct marketing regime, when it comes to the specific act of sending a direct marketing communication to a data subject, the applicable obligation will be that provided in the PEC legislation, not in the GDPR. That's all I want to say on the GDPR for now. With respect to the predecessor legislation, the DPA 98, I don't want to spend any time on this. Effectively, we say because such differences there are across the two schemes don't make any difference for the purposes of this appeal. Turning next then to PECA, which is at tab 2 of the authorities bundle, the main authorities bundle. So PECA was enacted to implement the e-privacy directive. It's legislation that in effect seeks to complement the data protection legislation, including by placing specific constraints around the use of cookies and the sending of direct e-marketing communications. The material definitions are set out in Regulation 2.1. The most important provision is Regulation 2.1 itself, where we see the definition of consent, and we see that it is the data protection definition that applies. You may also want to note the definition of direct marketing and also the definition of a user. Then Regulation 4, which is at page 54. I accept that if you look at Regulation 4.1, it seems to cut across Article 95 by saying in effect that the data protection obligations subsist, PECA notwithstanding. What we say is you have to read this provision consonantly with Article 95, and that means that PECA doesn't seek to disturb the conclusion that data protection obligations don't apply in respect of matters within the purview of PECA. Regulation 6 is concerned specifically with cookies. I imagine the court knows what a cookie is at this point in time, but in a nutshell, it is a small piece of text that's placed on a person's device when they visit a particular website, which then enables the device to be recognised, and it can also enable web pages that the device user has visited to be remembered and or identified. Now, in summary, Regulation 6.1, read together with 6.2, generally prohibits a person placing cookies on a user's device, save where the user has been provided with clear and comprehensive information about the purpose of the storage of that information and that the user has given their consent. Regulation 22 concerns the sending of direct e-marketing communications where they're unsolicited. And it's clear from from Regulation 6, Regulation 22, that such communications, where they're unsolicited, may not be sent without consent. There is an exemption that's provided for under Regulation 22.3. You'll see it's fairly narrow in ambit. There is a further exemption concerning charities, but that wasn't enforced at the time the court decided this case. In terms of enforcement, the ICO has powers to enforce PECA compliance. That's provided for in Regulation 31. And then under Regulation 30, which is page 60, persons can claim compensation for a breach of the regulations. But under Regulation 32, a defence is available if the defendant proves they've taken such care in the circumstances as was reasonably required to comply. I just pause there to note that the PEC directive made no provision in respect of the recovery of compensation. This is a domestic invention of a set of provisions. As for the question of how the defence could be invoked in a case where the claimant was arguing they were direct marketed to in the absence of valid consent, well, it seems to us that most obviously it may be relevant where the defendant had, for example, used a processor to obtain the consents, and the processor had, unbeknownst to the defendant, messed up the consenting process. That's the sort of situation which one can imagine that the defence might be relevant. We say it is straightforwardly impossible, however, to suppose that this provision can somehow be the tail that wags the data protection consent dog. It is a defence that appears in secondary legislation enacted under separate legislation, where the relevant provision is not even a requirement of the primary legislation. The notion that you should approach the construction and application of the principle of consent in the GDPR by reference to the availability of the defence under Regulation 32 of PECA seems to us, with respect, completely unreal. And I repeat that even if the defence was in principle available under PECA, that doesn't solve the legality problem. Your activities would still be unlawful. You would just have a defence to claims for damages. And what we say, it's just simply not logical to approach this provision on the basis that it affects the analysis of the construction of the consent concept. Then turning to the Gambling Act, this act was enacted in essence with a view to ensuring that online gambling service providers were offering their services to members of the public in a way that was appropriately safeguarded. In a way that appropriately safeguarded both individual users and the wider public. The Act seeks to achieve that objective by implementing a licensing regime, compliance with which is regulated by the Gambling Commission, which was established under Section 20 of the Act. The objectives of the regime are provided for in Section 1 of the Act, at page 61. And you'll see 1C, one of the objectives is protecting children and other vulnerable persons from being harmed or exploited by gambling. Then Section 22 is important, page 62. This provision concerns the Gambling Commission's duties. Notably, the effect of Section 22 is that in exercising its functions, the Commission shall aim to permit gambling, at least so far as the Commission thinks that is reasonably consistent with the pursuit of the licensing objectives. And it's important, we say, that the legislation adopts this deliberately permissive approach to gambling because what it reflects is a recognition by the legislature that provided that it is appropriately safeguarded, gambling is a valuable, protectable activity, something that should be permitted and not unduly constrained. I make those points to underline that the starting point for this case cannot be that gambling is per se a bad thing against which users need to be protected, something that should be kept to a bare minimum because of the risks it entails. Quite the contrary, the starting point must be that provided that gambling service providers are acting reasonably and responsibly, their activities should be regarded as valuable and protectable. And I wish to emphasise here that our position is that the vast majority of our millions of users can be taken to be gambling safely and in exercise of their own autonomous choices as to how they want to spend their money, enjoy their free time, and ultimately live their lives. Notably, that was something that the court appeared to accept because at paragraph 186 of the judgment, the court referred to there being a subset, what she described as a small minority of online gamblers who are vulnerable by reason of their having a gambling disorder. So the court itself appeared to accept that the majority of our users were gambling perfectly safely and were not at risk.
Was there evidence about that? I mean, I just... This...
I didn't do the trial at first instance.
No,
what Mr. Hopkins tells me is there was no data on the issue, but as you'll see, the court has accepted that the way the court puts it in terms is there was a small minority of online gamblers.
But it's a lawful activity. Do you need to go further than that?
Well,
in
I
this
mean,
context?
we don't, but all I'm underlining, the point that I'm trying to make is that we're in a world with this judgment where, in effect, we cannot direct market to our millions of users who are gambling perfectly safely, and that's a problem, we say. It's a problem for our commercial interests, our Article 10 rights, and the Article 10 rights of all our millions of users who are gambling safely and who have opted in to receiving marketing because they want it. Coming back to the provisions of the Gambling Act, the next provision I'd ask you to look at is Section 24. Here we see that the Gambling Commission is required to issue codes of practice about the manner in which gambling services are provided. Section 24.2 sets out what the code should cover. That includes describing arrangements that should be made to protect vulnerable persons from being harmed by gambling. 24.3 makes clear that a code may include provisions about gambling advertising. 24.8 provides that a failure to comply with the code doesn't generally in itself create any liability. But Section 24.9 provides that a code is admissible in civil proceedings and shall be taken into account by the court where relevant, and also by the Commission in exercise of its functions. I'm going to come on to the relevant code of practice in a moment. But then next, Section 33. Under 33.1, it is generally an offence to provide services to provide facilities for gambling. But 33(1) doesn't apply if the person holds an operating licence authorising the activity and the activity is a licence. Then section 82. Section 82 in effect makes it mandatory for the licence holders to comply with any social responsibility provisions set out in the relevant code of practice. That includes in effect all the provisions in the code of practice aimed at tackling the issue of problem gamblers. Now the code of practice relevant to this case you'll find in tab 40 of the authorities bundle, which is page 1156 bundle. This document forms part of a wider document known as the licence conditions and code of practice, or the LCCP. I'd invite you to read in particular the provisions on 3.4 in 3.43, which you find at 1157. And I'd invite you to note in particular paragraph 10, the requirement that service providers cease marketing where there are strong indicators of harm. What we see here is a careful and considered licensing regime that specifically seeks to recognise and address the issue of problem gamblers and then to ensure that their interests are being properly safeguarded, not least in the context of the service provider's direct marketing activities. And we say it cannot be right that a service provider could get everything right under the legislation that's been enacted by Parliament to protect the interests of vulnerable gambling service users, including in the context of direct marketing activities, and yet still find themselves falling foul of generic data protection laws based merely on the fact that the service user happened to be subjectively impaired. And yet that is the result of this, which this judgment aims. We say that outcome is very obviously wrong in law. Just before we leave the legal framework and on the subject of safer gambling, it's also important that I put on your radar the recent judgment of this court in the case of Gibson and Betfair. Gibson is an important case concerning whether gambling service providers owe a common law duty of care to their users. It follows on from an earlier Court of Appeal judgment in the case of Calvert and William Hill, where the Court of Appeal rejected an argument that William Hill owed a general duty of care to its customers. In essence, Mr. Gibson brought a claim against Betfair on the basis that it had failed, either knew that he was a problem gambler or failed to take reasonable steps to assess whether he was a problem gambler in circumstances where he ended up gambling a load of money, and his position was that effectively that Betfair had breached its statutory obligations under the Gambling Act because it didn't properly implement and apply the safer gambling regime in respect of him, that it was relatedly negligent, and he also brought a claim for breach of confidence. The breach of statutory duty claim was brought on the basis that Betfair either knew he was a problem gambler or reasonably to have known he was such, and that it therefore breached its obligations under the LCCP by continuing to provide him with services. The High Court dismissed all of the claims. Paragraph 3 of the judgment, sorry, just a few notes, it's tab 24, page 566. I don't suggest that you need to look at it now, but so that you have it for your notes. Paragraph 3, the court dismissed the claim breach of statutory duty on the basis it concluded that Betfair didn't know that he was a problem gambler and that there was no reason why it ought reasonably to have known he was a problem gambler.
Can you give that reference again?
Yes, it's paragraph 3 of the judgment.
No,
So,
but what was the page number?
so it's page 566, tab 24, I'm grateful.
566, thank you.
So in effect, the judge dismisses the safer gambling claim on the basis that Betfair didn't have the requisite guilty mind, whether actually or constructively. And at paragraph 4, we see the court also rejected the claim in negligence on the basis that Betfair didn't owe relevant duty of care in all the circumstances. And you'll see from paragraph 5 that the court also rejected the breach of confidence claim. Mr. Gibson's primary ground of appeal in respect of the judgment was that the court had erred in its approach to whether Betfair had actual or constructive knowledge that he was a problem gambler. The court rejected that ground, and indeed all of Mr. Gibson's other grounds. In summary, it held that the court's analysis of the knowledge issue, the mens rea issue, was unimpeachable. It's worth just briefly looking at the reasoning where the Court of Appeal analyses the court's assessment of these issues. The particular paragraphs I'd ask you to look at are paragraph 33, which is on page 574. You'll see in this paragraph the court noting that there was no requirement at the time to assess affordability. The same is also true in respect of our case. Note also paragraph 40, the third sentence. What the court underlines here is that it's practically very difficult to discern that someone is a problem gambler from data analysis alone. That is a point that affects all gambling service providers when they're trying to assess whether a person is at risk of harm.
If I've understood correctly, this was essentially an attempt to reverse the judge's findings of fact.
Yes, quite, which failed because the findings were unimpeachable for the reasons the court sets out. At 43, paragraph 43, we see that Mr. Gibson's challenge to the judge's conclusions rested on an assertion that rested on an assertion that where the court went wrong is that it ought to have found that Betfair was remiss in its approach to safer gambling compliance. And we see the court rejecting that case essentially because Mr. Gibson's complaint that the safer gambling regime adopted by Betfair was deficient was not made out on the facts. That's dealt with at paragraphs 45 to 47. Now just pausing there, RTM could have, but did not bring a claim against my client based on an allegation that we failed him on the application of the safer gambling principles, such that we breached the Gambling Act or alternatively were negligent and liable to him for that reason. Instead, he confined himself to claims brought under the data protection legislation and PECA. Now, it was our position before the High Court that it would be wrong in principle to allow RTM to use his claims to, in effect, introduce new and more stringent safer gambling obligations by the back door through an application of data protection principles. And that is a position we maintain before this court. It seems to us that, unfortunately, that is exactly what the court has allowed in the instant case, because it has effectively concluded that we face a form of strict liability in our dealing with users who happen to be problem gamblers, effectively irrespective of the mens rea element that underpins the safer gambling regime. We say that is completely unprincipled and produces an acute dissonance within the legal framework that framework cannot withstand.
Well, that point has some limits, doesn't it? Because we've got, on the one hand, EU legislation and on the other, domestic. And there can be dissonance. It's not a single legislative mind being applied to the regimes.
I have to accept that, and Mr. Knight makes some quite pertinent criticisms of our lex specialis arguments. So I don't seek to press those arguments before you. But we have to come back to the point, this is a regime that is designed to achieve proportionate results where the expectations that are set for the controller are in effect what's reasonable in all the circumstances, as we saw from Article 8. And we say it is completely dissonant then to say, well, you end up with a result that's completely at odds with a specific regime that is aimed at protecting the interests of problem gamblers. And there's a wider point to be made here about the oddity of treating data protection consent as dependent on the subjective state of mind on the data subject, when in the significantly analogous context of contract law, the approach is uniformly objective. So as this court, I know, will know only too well, even strict incapacity doesn't affect the validity of a contract unless the other contracting party is on notice of the same. That principle was established over 130 years ago in Imperial Loan and Stone, which is referenced in the footnotes of the ICO's submissions. We have copies if you would like to look at it.
Isn't that a slightly rocky road to go down, given that the directive is supposed to have EU-wide effect, and some EU systems of contract do not apply quite the same objective test.
I
as our
see the
domestic-
difficulty.
our domestic law contract.
I see the difficulty. I mean, all I would say is in the context of contract law, as a matter of common sense, how does it work? How do you have legal certainty, which is a principle of EU law?
In terms of domestic contract law, you're absolutely right, but not all systems of law in the EU operate to those principles.
I won't press the argument any further on that basis, save to say that legal certainty is a general principle of EU law. How could you ever achieve legal certainty in the context of contractual arrangements if the contract could effectively be avoided as a result of something that's completely unknown and unknowable by the other party? So beyond that, I won't press the point. Moving on then to the second, sort of the fourth section of our submissions. This is where we look at the jurisprudence and guidance specifically on the issue of consent. Now, I can be relatively short here because whilst there are a number of judgments that look at the issue of consent, including a number of CJU judgments, they don't actually, most of them grapple with the question we're trying to grapple with in this case is, how do you judge the question of consent? Is it from the perspective of the data subject and subjective, or is it from the perspective of what the controller ought reasonably to have known? Instead, the judgments, for the most part, address completely conventional questions concerning the adequacy of the controller's consent mechanism, see Planet 49, or whether there was a structural imbalance in the relationship, as in the case of dominant market position, see Meta platforms. That said, we say it's telling that all of the cases in this area do focus on these sorts of objective, conventional issues. What's going on in the four corners of the relationship between the data subject and the controller? Because we say that really does underline that that's where the focus should be in the context of the application of the consent concept. Just worth pausing there to note paragraph 40 of Planet 49, where, and it's at page 651 of the authorities bundle, where the court addresses the informed element of the consent test. Paragraph 40, page 651. Sorry, it's Orange, I'm referring to the wrong judgment. Many apologies. It's Orange Romania, not Planet 49. So here we see the court addressing the informed element of the test for consent. And the court notably approaches this issue on the basis that what matters is the adequacy of the controller's transparency materials, and whether those materials are such that they enable the data subject to determine the consequences of their consent, not whether the data subject in fact subjectively cognized the consequences of the processing by reading the privacy policy. That said, there is one authority that does specifically ponder the subjective stroke objective question, and that is the judgment of the Court of Appeal in Cooper, which you have at tab 15, page 256. And I should immediately say we're very grateful to the ICO that introduced this authority into the appeal, because it is really, we say, the final nail in the coffin when it comes to attempts to defend this judgment. Just in terms of the background to the judgment in Cooper, Mr. Cooper had brought a claim under the DPA against his former employer, the National Crime Agency, then known as SOCA. The claim was brought on the basis that SOCA had acted unlawfully by obtaining information about the fact he'd been arrested from Sussex police and using that information to dismiss him. Now, as we see from paragraph 80 of the judgment, which is at page 273, at the material time, the ICO had issued a data sharing code of practice, which provided, if you look at the bottom of 273, it provided as follows: there must therefore be some form of active communication where the individual knowingly indicates consent. If you're going to rely on consent as your condition, you must be sure that individuals know precisely what data sharing they're consenting to and its implications for them. They must also have genuine control over whether or not the data sharing takes place. Now, the NCA contended that the processing had a lawful basis because the terms of Mr. Cooper's contract with the NCA meant that Mr. Cooper had consented to the processing in issue in that case. The first instance judge agreed. We see that from paragraph 98 of the judgment at page 277. Then at 101, which is on page 278, we see that Mr. Cooper argued, based on the code of practice that we've just looked at, that there was ambiguity in his consent because of the need for knowledge on the part of the employee. It hadn't been established that he positively knew what he was signing up for. We see from paragraph 102 of the judgment that Lord Justice Sales, as he then was, roundly dismissed that argument that Mr. Cooper advanced. I just ask you to read that paragraph, please. What we see from this paragraph is the Court of Appeal recognising that this is a scheme which effectively can't work if consent turns on the subjective state of mind of the data subject. So what matters is the outward manifestation of consent, which comes back to my Lord's point about indication, something that is manifest in the relationship. And in the case of a contract, that falls to be determined by reference to what has been agreed. We'd say in the context of a direct marketing consent mechanism, it entails looking at the relevant mechanism. But we say the Court of Appeal's conclusion is clear as a bell. It's a conclusion that perfectly chimes with our case and should obviously be followed by this court unless there's a good reason for departing from it. We say there is no good reason not to follow it. Mr. Cooper makes a number of points, RTM makes a number of points in response to Cooper, which he deals with at paragraph 12 of his submissions in response to the ICO submissions. The first point he makes is, this was a briefly considered point within a long list of issues. Well, the fact that it's a conclusion that is pithily expressed, as is always the way with Lord Sales' judgments, doesn't undermine its force. The Court of Appeal has, in a few short words, landed on the essential difficulty with the subjective test, which is that it doesn't work as a matter of basic logic, because you can't have a compliance regime that rests on matters beyond the controller's knowledge. Next, RTM suggests that the judgment is of limited assistance because it was concerned with the pre-GDPR regime and doesn't address relevant CJEU jurisprudence. The difficulty with that line of argument is that there's nothing in the GDPR or the jurisprudence that supports a different approach being adopted to one that Lord Justice Sales adopted in Cooper. The problem with which the Court of Appeal landed on in Cooper exists just as much under the GDPR as it does under the DPA. Then RTM says that he accepts that consent won't be valid unless it's outwardly manifested. But that's very obviously not the point which Lord Justice Sales was making. The point he was making was that the consent concept could only be rendered workable if it failed to be judged by reference to what could be objectively discerned within the four corners of the relationship, and that subjective considerations couldn't therefore be relevant to the analysis. We say that conclusion is sound and should be followed by this court. Then RTM says the more difficult question on the facts of this case is whether an apparent external manifestation, such as a text box, was sufficient in context to meet the relatively high threshold imposed by the case law. I've already addressed you on the the relevance of this notion that the threshold is relatively high and what that should mean. As for the remainder of my learned friend submissions, well, it would make sense if the judge decided this case based on the question of whether judged objectively our consent mechanism was up to scratch, such that it was capable, or alternatively incapable, of yielding valid consents from users. But if we're right, and the court decided this case not by reference to those conventional objective issues, but instead by reference to RTM's subjective state of mind, then these submissions ultimately take my learned friend nowhere, because that approach to consent is straightforwardly wrong in law. As for the guidance, well, I'm going to leave it to my learned friend to persuade you that there's something in the guidance that supports the subjective approach to consent adopted by the judge. For our part, we simply say there's nothing in the guidance that goes beyond the conventional, objectively preoccupied approach. So I'll now, if I may, turn, if you like, to the main event, which is the judgment itself. I want to take you through the judgment in some detail, but before doing so, I'm keen to set out the following headline points that we make with respect to this judgment. First, we accept that if you adopt a microscopic approach to the court's reasoning, one that focuses in an abstracted manner on this or that sentence or this or that paragraph, you might persuade yourself that actually the court was applying the conventional objective approach to consent. However, and this is my second point, we say that it is wrong to indulge in that kind of microscopic, abstracted analysis, in essence because it risks the court failing to see the wood for the trees. What we say is that the task for this court is to stand back and look at the judgment as a whole in order to discern the core thrust of the court's reasoning. We say that approaching the judgment in that way leads inexorably to the conclusion that the court misapplied the law by allowing considerations related to RTM's subjective state of mind to infect the court's analysis of a consent issue. Third, whilst of course you will want to, and indeed should, look at the entirety of the court's reasoning, it's nonetheless telling, we say, that in its summary conclusion, the court gives every impression that it treated RTM's subjective state of mind as being not only relevant, but the decisive consideration. Merely by way of illustration, I invite you now, at the outset of my submissions on the judgment, to cast your eyes over paragraphs 203 to 204 of the judgment, which you'll find at page 118 of the core bundle.
But in a sense, if you use this particular battle and establish that the objective test is the right test, which is in a sense what Mr. Knight is arguing, you've won the war.
Well,
I mean, that's the important point of principle for the part.
Well, I suppose Mr. Knight would put the point the other way around. If he can show that actually the court decided matters on the objective conventional basis, we lose, because that aligns with the case that he put, so kills our ground one, and it means that the court didn't approach the issue erroneously, so that kills our ground two. So a lot turns on how the judgment falls to be construed, and I have to persuade you that subjectivity infected the court's analysis on consent. I say that is not at all a difficult threshold for me to cross. So if I could invite you to look at paragraphs 203 to 204 of the judgment, which are page 118 of the core bundle. Oh, I'm so sorry, 119, I'm grateful. We say in these paragraphs, the court gives the very firmest impression that it decided the consent issue against us based essentially on its conclusions as to what was going on in RTM's mind at the time. So not what we knew about what was going on in his mind or what we ought reasonably to have known about what was going on in his mind, simply subjectively what was happening in RTM's mind at the time that he opted into receiving direct marketing. What we say is if you stand back and look at the court's reasoning as a whole, it's very clear that the court was not in that passage mischaracterising its ratio. Instead, the summary conclusions absolutely reflect the broad thrust of how the court decided the consent issue in this case. Fifth, we will spend some time looking at the three-strand test for consent that was devised by the court. As to that test, we say first, it is a test that has clearly been invented by the court. You will not find a reference to this three-strand test in any of the authorities before you. Second, we say it is a test which, for all its claimed preoccupation with objective considerations, ultimately collapses back into a subjective test for consent, one that concerns itself essentially with the inner workings of the data subject's mind. Third, it is at the very least a test which treats the inner workings of the data subject's mind as being a relevant consideration.
Where do you, I know, I'm sure you'll come to this, but where do you say this comes from? You know, obviously, we've
Well,
understand your argument.
that's more for Mr. Knight, because we say it does not come from the authorities. It does not. The authorities adopt the completely conventional orthodox approach. And as we've seen in Cooper, no subjectivity in the analysis because it would
But in particular, the three-strand test.
it's not in the authorities.
No, I follow that. But
Yeah.
what was anything said in submissions, or
Well,
I can
it
see
needs
Mr.
to be
Hopkins shaking his
remembered,
head.
our ground one,
Mhm.
this analysis of the consent issue was never put to my client. It formed no part of RTM's case. It wasn't the case. The case we were answering, to get ahead of myself and deal with ground one, is a completely conventional orthodox case. First, the RTM didn't in fact opt in, didn't, set his marketing preferences to the effect that he wanted to receive direct marketing. Second, even if he did, objectively, our consent mechanisms weren't good enough because our transparency materials didn't adequately explain the underlying nature of the processing. That was the conventional case that we faced, that we thought we'd answered through our evidence and through our
You
arguments.
say this sprang fully armed from the judge's head.
Well, it's for Mr. Knight to persuade you that it came from somewhere else, because we can't locate it in any. Yeah, sorry, that is absolutely what we say. Yeah, sorry, I misspoke.
The judge said in paragraph 148, there is the subjective element of the individual's state of mind, what they actually thought about, understood and desired, and that actual and high-quality individuated consent has a palpable presence in the authorities as at least an aspirational standard. And you say there's nothing there.
There's nothing there.
And
There is,
for
of
Mr.
course, a
Knight to say-
discussion.
To show us there is, because I don't think, I've looked to see where in the authorities that palpable presence can be found, and you say it's not there, so Mr. Knight will tell us where it is.
So it's definitely not there. What the court seems to be saying is this is an inevitable aspect of personal autonomy, and this scheme is about protecting personal autonomy. So it flows as a matter of principle.
That's a different point. This is a point about authorities.
Yes, there's
Um,
nothing in the authorities. The authorities, so Cooper is strictly against that approach because it says subjectivity is not relevant. Obviously, we didn't make any submissions on Cooper before the first instance court because we had no idea this was where the judge was going. But if you're asking me the question, is there anything in the authorities that supports subjectivity being relevant to the consent analysis? The answer is no.
Obviously, you're going to say no, but just wondering whether you knew where it might have come from. Where you'd say she misinterpreted the
That's a
authority,
matter for
but-
Mr. Knight, not for me.
Right, thank you.
So we say it's a test that doesn't emerge from the authorities. It's a test that, for all its claimed preoccupation with objective considerations, ultimately collapses back into subjectivity, or at least treats subjective considerations as being relevant. And we say those points alone mean this judgment cannot stand because subjectivity can form no part of the analysis on consent. Sixth, and related to my first point, we accept that at certain points in the judgment, the judge does make some observations about the quality of my client's consent mechanisms. The problem for RTM is that, as we shall see, these are passing comments and did not form the basis for the court's conclusions on consent. So having made those outline points, I'm now keen to take you through this judgment, unless the court thinks it may be convenient to break now before.
Well, I'm happy to break now, provided we sit again at 5 to 2. All right.
Court rise for April.